This ain't TV drama. This is real court. No scripts, no second takes, just raw justice. One courtroom, one mistake, everything on the line. In America, the record never forgets.
The son, 71061 want to be Mr. Edward Poe. Mr. Poe, state your name for the record. Edward Poe.
Thank you.
So, Judge, today's date and time scheduled for preliminary exam. The defense counsel, we're prepared to proceed, Judge.
When that is correct, it's a daytime set for examination. There one witness and officer in charge, Deputy Ward, let me know that he is on scheduled vacation and he's off this week. He's on I would be asking for a brief adjournment. That's schedule. I understand it. That's not the court's decision.
And Judge, just for the record, defense counsel, we will move for dismissal, Judge. I believe the people have had more than enough time to secure their witnesses for this particular exam, Judge. Again, I'm not the people, Judge, but I'm not even certain how much.
You want to keep going when you're winning?
Thank you, Judge.
I've been saying that all day to people. They're just, I don't know. It's my friendly face. People want to talk to me. Yeah, maybe. All right. People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you very much, Judge.
All right. Thank you, sir. Have a good day. Yes. Court calls the case People versus Samuel Allen Dabney.
Ready, Judge.
Good afternoon, Your Honor. Laura Grant, on behalf of the people.
Good afternoon, Judge. Attorney Kerry Mitchell appearing on behalf of my client, Samuel Allen Dabney, who's approaching to my right. Today's the date set for a preliminary examination, Your Honor.
Nope, right here. Nope, switch. That's right. Yeah. All right.
Today's the date set for an exam, Judge. We're going to waive that examination. My client understands that he has a right to a preliminary examination, and that if an examination was held, the people would have to show that a crime was committed and that he probably committed that crime. He wishes to waive those rights.
Your Honor, I did discuss this with defense counsel, and we discussed that I would be filing an amended information with the corrected counts. May I approach with that information?
That is correct, Judge.
So
he would be waiving as to counts 2 and 3, and count 1 would be dismissed. Counts 2 and 3 are child sexual abuse of material, aggravated possession, the 10-year felony.
okay,
20-year felony.
so he's the original charge. Let me go
The
to
75145C2, which is a 20-year felony, Judge.
I got that.
Oh, okay.
So I'm just going on the count. So count 1 is going to be dismissed. He's waiving up on counts 2 and 3.
That's correct, Your Honor.
All right.
That is correct.
You understand that, young man?
Speak up.
Yes.
All right. And you understand that you're waiving your right to a preliminary examination where the people would have to show by the standard of probable cause that these offenses were committed and that you committed them.
Yes.
Okay. And you understand you're not going to have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Your Honor, as to the matter of bond.
Oh, hold on a second. Preliminary examination having been waived, defendant is bound over to circuit court on counts 2 and 3. Count 1 is dismissed. Yes, go ahead as to bond, but as to the circuit court arraignment, you waive formal reading of the complaint
Yes, Judge.
or the information. Stand mute at this time.
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
January 15th at 1:30 with Judge Slay.
January 15th, 2026, 1:30 before Judge Slay. Yes, as to bond.
Your Honor, as to the bond, I believe that the bond is really excessive. It's $500,000 based upon the amended charge, which is basically half of what he was facing. I believe an appropriate bond, and also my client has no prior criminal history whatsoever. I would respectfully ask the court to place a more reasonable bond considering the circumstances. I believe I'm not asking for a personal bond, Judge. I respectfully ask the court to give him a bond possibly 25,000, 10%. 500,000, I believe is really accessible. I don't know if the court remembers, they probably had 1,000 other cases since I last argued.
No, I remember you.
Oh, okay.
And maybe that's a good thing or a bad thing, but
Yeah.
I remember.
Well, I was hesitant because I gotta catch a plane tomorrow. I don't want to get locked up today, so otherwise I wouldn't mind, but.
Then maybe they'll hold the plane for you if you keep on.
May I?
Yes.
I would object to a change in bond. I did, Detective Morrison from Washington County is the officer in charge of this case, and I did speak with her today. She did a review of Mr. Alan Dabney's phone, and both in the report and in my conversation with her said that he had an overwhelming amount of child sexually abusive material on his phone, and it was accessible by her, not a forensic analyst. Just in reviewing his phone, he had an overwhelming amount of both images and videos, and prepubescent children. I think given that his bond is appropriate.
Yeah, I'm not going to go into everything that I said before. He was in a relationship with an individual. This individual, I believe that given the circumstances and the bond is just really excessive. I don't want to get into the other underlying facts about, and the people know that this other person that was the target of this investigation is the main character in this situation.
Let me ask this, and I understand that there have been a change in charges. I also know that sometimes when that happens, when there's a waiver up, it's a waiver up on 2, but given what would be this overwhelming amount of stuff, and again, I don't know what that is or necessarily quantifiably means, could there be potential other charges?
I mean, certainly.
I mean, I'm not suggesting it. I'm just trying to get a feel.
I think it was not, in my viewpoint, charged correctly at the outset. And so part of this was to ensure that he was waiving up on the correct charges. But yes, I mean, he's waiving up on counts 2 and 3, but technically every image or photo or video that he had could be another charge. So the answer is yes. As to like a different charge, I at this time don't think so. This did originate as a Canton investigation into, yes, correctly, a wider ring of people of which the defendant was part of, and he was residing in Ypsilanti, so that's why this case is changed.
And just briefly, Judge, the person that he was involved with that originated in Canton, those individuals were referred to the federal system and they were prosecuted in that realm. He is the only one that was not, and that is because he was not, in their opinion, a main character in this.
When you say they're the federal.
Correct.
Okay.
Correct, Judge. So, and I'll get into this when it gets to circuit court, but in relationship to them being on his phone, this other individual that got charged federal had access to my client's phone.
For everything in this, I will reduce the defendant's bond. I'm going to grant the motion in part, but not nearly to the extent that the defendant wants to reduce. I'll reduce his bond to a $250,000 cash surety bond.
Court consider 10%?
If I would have said it.
Okay, well, I want to catch that plane, Judge.
Yes. You're doing everything to not, but no, I will not consider 10%. Thank you.
Have a good day.
Court calls the case, People versus Merlin Bement. That's what? Oh, that's the recall. Is the I just want to make sure it's working. Did Ken let you know? Is it working?
Yes.
Okay.
And I can see it.
gonna wait till.
Okay.
Ashley Feltus for the people.
Assistant Public Defender Ben Benowith for Mr. Bennett, who stands to my right. Can you state your name for the record? What's your name? Okay. Would these headphones help you? Can you hear a little bit? Okay. You want to try these? No? Okay. Your Honor, we would like to set this matter for exam.
You have all of the discovery,
Yes, Your Honor.
and would the people have their witnesses available
We will
the
try.
13th?
The 13th?
Preliminary examination in person will be set January 13th, 2026, 9 a.m. before a 15th District Court judge. Bond will continue.
Yes, may we address bond, Your Honor?
You may.
My client is 69 years old. I looked him up in X-Jail. The only thing other than this case was a trespass warrant from 2011, which means he hasn't been arrested since 2011. I looked at his iChat, and that was clean. I don't know if he has out-of-state or suppressed cases, but it looked clean as far as what I can get. I'd indicate to the court his current bond is $500, and he can't make that. We'd ask the court to reduce that to a PR. This is a single witness case. No weapon was recovered, and there's no video. Mr. Bennett is experiencing homelessness, but he's fine with staying at the Delana Center if the court would allow it. And he's being 69 years old. He's obviously retired.
Your Honor, the defendant has extensive out-of-state history from Florida and California, dating back almost 50 years to 1977. Of course, I can't see all of the charges as clearly as I would be able to if they were in the state of Michigan. But what I was able to review showed an extensive assaultive history, including what was literally strong-arm rape, I believe, as one of his cases. Assaultive cases as recently with arrests in 2024. I do not believe he has strong ties to this community, so I would consider him a flight risk. I also think that he is a danger to the community should he be released. This case involves an allegation of him threatening someone with a knife. And I would ask the court to continue the bond as set. It is frankly much lower than our original request.
Anything else?
Nothing else for the court. I guess I could ask the prosecutor to, at some point in the future, potentially send me the information on the record that the defense does not have, but that wouldn't have to be today.
I'm going to deny the request at this point and continue his bond as it said. I think it's appropriate. And certainly it can be raised on the 13th of January.
Thank you, Your Honor.
Thank you.
We're in front of Your Honor on the 13th?
No, 15th, whatever that might be.